Ayes are 63 noes, 56. Clause 1 will stand part. The question is now that Clause 2 stand part. Clause 2 is on the commencement, a reasonably precise and tight debate. Keith Locke, are you seeking the call?
I am seeking the call.
Keith Locke.
Thank you. I think that the commencement date should be put out several years. No, I think 10 years probably would be a good start. And I say that because the bill itself is one that does offend basic rights, I think. There was a discussion previously on the title, which unfortunately the Green Party didn't get a call for.
We're here.
I was here, and I...
Order.
And it is an imbalanced bill. It talks about workers' secret ballot for strikes, but doesn't take into account that the other side of the industrial equation, that is employers, should also, if there's going to be any secret ballots, have a secret ballot as is proposed in a further amendment that we'll be discussing later, whereby shareholders should be balloted secretly before they lock out workers, because there is equality in the Employment Relations Act on strikes and lockouts in that respect. And I think it should be put out for 10 years, because if you look at the justice of it, why should the state control voluntary organisations? And that's what this is about. In spite of the National Party's talk about freedom and nanny state and all the rest of all the things I've talked about over the years, this is the ultimate nanny state, that the state is controlling such an intimate thing as people deciding how people in a voluntary organisation can decide collectively about whether they should go on strike. That shouldn't be a role of the state. And in fact, if you look at the practicalities of the situation, I've been in several situations where there have been strikes. Sometimes there's been secret ballots, and that's been very good. Sometimes it's been impractical to have secret ballots. And that is the situation, and that is the way submissions went to the Select Committee. The Service Workers Union, and I think the Unite Union, put across the idea that in some of the industries they organise, such as fast food outlets and whatnot, it is impractical to have a secret ballot. So it shouldn't be in law. And the Green Party completely opposes this provision being in law. It's impractical and will act against the interest of unions. And also, as was mentioned in some of the previous discussion, it will allow, because it's in statute law, it will allow employers to try and trip workers up all the time and say, well, this person didn't get this worker didn't get a notice of the secret ballot because they might have shifted address or something, and hold up the industrial action or the strike action of the union concerned until that's all sorted out in a court. And they can bankrupt, because the employers always have more money than the unions. They can also bankrupt the unions by dragging them through repeated court proceedings about whether a strike ballot was properly implemented. So this is highly prejudiced against one side of the industrial disputes, that is the workers. So I think putting the implementation of this bill out for 10 years would give us time to think about it, give time for members of this Parliament to perhaps go down to workplaces and talk to workers, go into fast food outlets, talk to the Unite Union, talk to the Service and Food Workers Union, talk to employers about whether they want to have an imposition on them of all their shareholders having to secret ballot before they lock out, as might be the case if Darren Fenton's amendment is passed under Clause 4. So, there's still water to go under the bridge, and I think 10 years water going under the bridge would be quite good.
Carol Beaumont.
Thank you very much, Mr.